A very good evening to all our viewers. I am Urvashi Chauhan and I welcome you all to Judicial Service Examination Preparation Series by LiveLaw Academy. Today we have with us an important figure who will be speaking on charge, discharge and framing of charges. It is indeed my honor to welcome Justice V. Ramkumar, former judge of the High Court of Kerala and our patron and chief mentor. A very good evening, sir, and thank you so much for gracing us with your presence.
Thank you.
Before we start, I would like to briefly introduce Sir to our viewers. Justice V. Ramkumar completed his LLB from Government Law College, Mumbai and enrolled as an advocate at the High Court of Kerala in the year 1979. From 1983 to 1985, Sir served as the Secretary of the Rural Committee constituted by the Kerala High Court. In 1987, Sir was directly recruited as a District and Sessions Judge. He has served as the Law Secretary to the Government of Kerala under 3 different ministries. And in January 2004, Sir was appointed as a permanent judge of the Kerala High Court, a position that he held until his retirement in May 2012. Sir has also authored many books and has written articles on important legal concepts. And some of these, if you'd like to read, you can also find on LiveLaw. I also wanted to tell our viewers that LiveLaw Academy is very proud to have launched its Judicial Services Preparation course. We will tell you more about it later. I now invite Justice V. Ramkumar to start today's session. And over to you, sir, please.
Thank you, Urvashi. Good evening, friends. Charge, discharge and framing of charge. What does it mean? And who is to do that? Every criminal court has a responsible duty while discharging an accused or while framing a charge against him. An erroneous order discharging an accused or see there is some once again I had my notes that is see there's a screen sharing. There's a sharing of notes. You see the chart A and the screen share is yes. An erroneous order of discharge or a wrong order of framing charge against the accused can both result in failure of justice. While a person who has really committed an offense should be brought to justice and he should face trial before a criminal court, a person who is really innocent and has been falsely implicated should not be subjected to the ordeal of a trial before a criminal court. A judge or a magistrate has to independently apply his judicial mind to the prosecution allegations and the materials produced in support thereof before embarking upon the onerous or the responsible task of framing a charge against the accused. Now, if you examine till 1/7/2024, we had the Code of Criminal Procedure 1973 in vogue. Now that has been repealed by the Bharatiya Nagarik Suraksha Sanhita (BNSS) with effect from 1/7/2024. Now I will be reading the provisions in the CRPC and corresponding provision in the BNSS. Part A of Chapter 17 of CRPC, Code of Criminal Procedure 1973, comprising of sections 211 to 217, deals with the rules relating to the form of charges, and Part B of the said chapter, comprising of sections 218 to 224, deals with the rules relating to joinder of charges. So Part A is the form of charges, Part B, joinder of charges. In Bharatiya Nagarik Suraksha Sanhita, the corresponding chapter is chapter 18 instead of chapter 17 in CRPC, and sections 234 to 240 fall under Part A, and sections 241 to 247 fall under Part B. We will discuss those provisions in the sessions to come in future. Today I propose to familiarize you with the famous William Slaney's case. What is William Slaney's case? We will have an analysis of William Slaney's case. Anybody undertaking a study into the various nuances of the process of framing charge by a criminal court should know the celebrated case of William Slaney. When I heard this name for the first time, I was under the impression that it is an English case. But it was a pleasant surprise to me to learn that it was a leading Indian case in which the path-breaking verdict was rendered by a constitutional bench of the Supreme Court of India way back in 1956. This citation is William Slaney versus State of Madhya Pradesh, AIR 1956 Supreme Court 116, corresponding to 1956 Criminal Law Journal 291. The five great judges who comprised of the Constitution bench are S.R. Das, Acting Chief Justice, Justice Vivian Bose, Justice Jagannatha Das, Justice Chandrasekhar Iyer, and Justice Saeed Jafar Imam. This decision deals with the intricacies of omission, irregularity, and illegality in the framing of charge by a court. This case came up before the Constitution bench upon a reference by two honorable judges who felt that there was a conflict of judicial opinion by two earlier three-judge bench decisions in Nanak Chand versus State of Punjab, AIR 1955 Supreme Court 274, comprising of Justice S.R. Das, N.H. Bhagwati, and S.J. Imam, Saeed Jafar Imam, who was the author of that verdict, and Suraj Pal versus State of UP, AIR 1955 Supreme Court 419, comprising of Vivian Bose, Justice Jagannatha Das, and Justice B.P. Sinha, of which Justice Jagannatha Das was the author of the verdict. In William Slaney's case, three judges of the Constitution bench rendered separate but concurring judgments in which all of them held that there was no conflict between Nanak Chand and Suraj Pal. We will now straightaway deal with William Slaney's case. The reason for the separate judgment by Justice Saeed Jafar Imam was that it was he who pronounced the judgment in Nanak Chand's case, AR 55 Supreme Court 274. Paragraph numbers given, which I will be referring to, are those given in the AIR citation, All India Reporter citation, that is 1956 Supreme Court 116. Now coming to the actual occurrence in William Slaney's case. The details of the occurrence are discernible from paragraph 89 of the judgment of Justice Chandrasekhar Iyer and also paragraph 72 of the judgment of Justice Vivian Bose. I have given a small chart showing the interrelationship between the parties. If you can screen share that, not that, the interrelationship between the parties with Mrs. Waters at the top. That's it, the lower one. Mrs. Waters, PW20, who was examined as PW20 in that case, at the top. She had this, the Mrs. Waters, actually the occurrence took place on 12th February 1953 at 7 p.m. in the house belonging to Mrs. Waters and the sister, and Mrs. Waters was belonging to Jabalpur in Madhya Pradesh. She had a son and a daughter. Donald Smith was her son, and Beryl, who was examined as PW13, was her daughter. Beryl, the daughter of Mrs. Waters and the sister of deceased Donald, was residing in the above house belonging to Waters, Mrs. Waters. The mother and son Donald Smith, mother and her son Donald Smith were residing elsewhere. The person who was attacked and killed in the occurrence was the said Donald Smith, who is a brother of Beryl, PW13. The accused persons in this case were one William Slaney, first accused, who was the appellant before the Supreme Court, and his brother Ronnie Slaney. Even though Beryl was married to a gentleman in England, her husband, there was usual family bickering between them, which escalated into great quarrels between them. Finally, her husband turned her out and she had come to India, to Jabalpur, and was living in the house of her mother at Jabalpur. That is Mrs. Waters' house at Jabalpur. The first accused, William, eventually fell in love with Beryl, who also reciprocated his affection towards her. But she could not marry him because her husband had refused to give her a divorce. Deceased Donald, the brother of Beryl, did not like the intimacy between his sister Beryl and William Slaney. Donald used to make attempts to separate his sister from the first accused. On the evening of the date of occurrence, Donald Smith and his mother paid a visit to Beryl's house. To their dismay, they found William Slaney, the first accused, already in that house. There was a quarrel between Donald Smith and William Slaney. William asked Donald Smith to go away from the house. Unwillingly, William Slaney left the place, but returned a little later with his younger brother, Ronnie Slaney. William Slaney called Beryl, who was in the first floor of the house, and asked her to come down to him. But Beryl did not come down, but instead it was Donald Smith who came down to the courtyard. During the quarrel that ensued between William Slaney and Donald Smith, William slapped Donald Smith across his face. When Donald, who was a stout and well-built man, shook his fist against the face of William Slaney, the latter snatched a hockey stick from his brother, that is Ronnie Slaney, and dealt a blow on the head and 2 blows on the hips of Donald Smith. The skull of Donald was fractured in that single blow, and he died in the hospital only 10 days later. William and his brother were subsequently charge sheeted by the police for an offence punishable under Section 302, read with Section 34 of the Indian Penal Code, for intentionally or knowingly committing murder of Donald in furtherance of their common intention. Now, Section 302 IPC is presently Section 103 of Bharatiya Nyaya Sanhita, BNS, and Section 34 is presently Section 3, Clause 5 of BNS. During the trial of the case, it was proved that the fatal blow was dealt with by William, the first accused. Even though the skull of the deceased was fractured in that blow, he had survived for 10 days in the hospital. The postmortem doctor deposed before court that the head injury sustained by Donald was, though of a serious nature, it was only likely to result in fatal consequences. The trial judge acquitted Ronnie, the second accused, but convicted William, A1, for murder and sentenced him to imprisonment for life. This was affirmed by the High Court of Madhya Pradesh also. It was aggrieved by the said conviction recorded and sentence passed against William Slaney that he approached the Supreme Court. Now, in the Supreme Court, William Slaney, the first accused, argued that since he, along with his brother Ronnie, was charged for the offence of murder, punishable under Section 302, read with Section 34 IPC, and when Ronnie, the second accused, was acquitted, the liability of William, first accused for murder, ceased to be constructive. It was no more constructive because there was no common intention proved. And it became direct, and therefore it was impermissible to convict him without a separate and independent charge under Section 302. Viewers, I suppose you got the point. They were charged, both the brothers were charged under Section 302, read with Section 34, on the ground that the murder was committed by both of them in prosecution of the common intention of both of them. Now, A2, second accused, Ronnie Slaney, was acquitted. Therefore, the charge came to be on the shoulders of William Slaney alone. He argued that there is no independent charge of murder against me. There is only a charge that I, along with my brother, committed murder in prosecution of the common intention of both the accused. So he said, in the absence of an independent charge for murder, I cannot be convicted for murder. That was his argument. He then, for that to substantiate, to buttress that point, he relied on Nanak Chand versus State of Punjab, year 1955 Supreme Court 274, which was rendered by S.R. Das, N.H. Bhagwati and Said Jafar Imam. Said Jafar Imam being the author of the judgment. In Nanak Chand, it was held that where the charge against the accused was under section 302, read with section 149. As you know, section 149 is the other section for constructive liability, like section 34. So there the charge was under section 302, read with section 149 APC. And in that case, it was held that if section 149 became inapplicable, see, there should, for 149 to be roped in, there should be minimum five accused persons. 5 or more accused persons should be charged under section 149. And 149 is they should share the same common object. And if sharing the same common object, any one of them committed any act, every one of them will be held liable for that. No, in Nanak Chand's case, the charge was under section 302, read with section 149. And it was held that if section 149 became inapplicable, see, there can be situations where even though charge under section 149, with the aid of section 149, it becomes inapplicable either due to the total number coming down below 5. If the number of persons coming down below 5, then 149 cannot be invoked. So 149 will become inapplicable. Or even though there are 5 or more persons, the evidence will show that all of them did not share the same common object. In that case also, if the number came below 5, then 149 cannot be invoked. So the 3-judge bench of the Supreme Court, speaking through Said Jafar Imam, held that if 149 became inapplicable, the accused cannot be convicted under section 302 IPC alone without a separate or independent charge under section 302. And failure to frame a separate charge under section 302 was an illegality and not merely an irregularity. And section 302 and section 149 IPC are respectively corresponding to section 103 and 190 of BNSS. The accused in that case was further found to have suffered prejudice. It was also held that the accused had suffered prejudice. Even though Nanak Chand was the person who actually committed the act of killing, the court charge was silent in that regard. Court charge only said that all the 5 accused persons in prosecution of the common object of this unlawful assembly committed murder. That's all. Therefore, there was no separate charge of murder on Nanak Chand. On behalf of Nanak Chand, it was argued that as per court charge, the case which he was called upon to meet was the allegation that by virtue of section 149 IPC, he was vicariously responsible for the act of killing by a member of the unlawful assembly. Not that he killed. Being a member of the unlawful assembly, he had also committed murder along with the others. Hence, Nanak Chand contended that he had committed his contention was that he, on account of this charge, he did not elaborately cross-examine the doctor in that case, and therefore he had suffered prejudice. This contention of Nanak Chand was accepted by the 3-judge bench, which, however, remanded the case for retrial with a direction to frame a separate independent charge under section 302 alone. This is the conclusion reached by the 3 judges bench in Nanak Chand's case. When Nanak Chand was cited before the Supreme Court, it was brought to the notice of the court that another 3-judge bench of the very same Supreme Court in Suraj Pal versus State of UP, AIR 1955 Supreme Court 419, AIR 1955 Supreme Court 419. The citation is screen shared. 3 judges are Vivian Bose, Justice Vivian Bose, Justice Jagannatha Das, and Justice V.P. Sinha, of whom Justice Jagannatha Das was the author. That 3-judge bench had held that on a charge for section 302, read with section 149 IPC, if the constructive liability under section 149 IPC had become inapplicable, then failure to frame a separate charge under section 302 alone was only a curable irregularity and not an illegality as held in Anachand, and that a conviction under Section 302 IPC alone without a separate charge under Section 302 was permissible unless the accused can show that he had suffered prejudice. He had suffered prejudice. The court, however, held in Suraj Pal that the accused in that case had suffered prejudice and accordingly acquitted him, even though the finding was that failure to frame a separate charge under Section 302 IPC is only an irregularity, but though it is an irregularity, he had suffered prejudice. Therefore, he was acquitted in that case. Now, since it was felt that there was a conflict in the two decisions of in Nanachand and Suraj Pal, the matter was referred by a two-judges bench to a constitutional bench of the Supreme Court. That is how William Slaney's case came up before the 5 judges referred to above. Now, the findings of the Supreme Court in William Slaney's case is all the judges unanimously found that the principle that when the charge under Section 149 IPC became inapplicable, the accused cannot be convicted for murder in the absence of an independent charge under Section 302 simpliciter cannot be extended to a case involving a charge under Section 302 read with Section 34 IPC, as was in William Slaney's case. See, both the three-judge bench decisions were held to be not applicable because both those cases were, in both those cases, the charge was under Section 302 read with Section 149, not under Section 34. So, if 149 became inapplicable, whether the accused could be convicted under Section 302 without an independent charge under Section 302 did not arise in William Slaney's case. In William Slaney, the Supreme Court held that here the accused is charged under Section 302 read with Section 34. Taking into consideration the admitted case of the prosecution and the testimony of the eyewitnesses, the judges held that William Slaney, the first accused, had not come to the place of occurrence armed with any weapon, thereby ruling out any premeditated plan. So, Section 34 contemplates a premeditated plan. There should be a preconceived plan between the accused to cause the death of Donald Smith. There was no such plan. He was already in the house, and when asked to go out from the house, he went away. Then later he returned along with his younger brother. Younger brother was having a hockey stick, but then he only asked his lover to come down from the house. Before she could come down, her brother came down, and there was a quarrel ensued between the deceased and Slaney, William Slaney. That is how the occurrence took place. And the judges further held that the act of William Slaney hitting on the head of Donald Smith with the hockey stick snatched from the hands of his brother Ronnie Slaney was an instinctual act consequent on the deceased shaking his fist against the face of William Slaney. It was also held that medical evidence showed that after sustaining the fracture, Donald survived for 10 more days in the hospital, and that the injury inflicted was, according to the doctor, postmortem surgeon, likely to cause death. Taking into consideration that the overt act of hitting of the deceased was done by William Slaney alone, the bench held that it could not be said that failure to frame an independent charge against him under Section 302 IPC had caused any prejudice to him, and that no prejudice had in fact been suffered by him. William Slaney was accordingly acquitted of the charge of murder punishable under Section 302. Instead, his conviction was altered to culpable homicide not amounting to murder punishable under Section 304, the latter part of Section 304 IPC, and his sentence was reduced to rigorous imprisonment for 5 years. See how beautifully the facts of the case were analyzed by the Constitutional Bench, by the judges. They did not confirm the conviction for murder, concurrently held by the trial judge as well as by the High Court. Instead, they said that after all, he suffered only one blow on the head, which was not instantaneously fatal. He had survived in the hospital for 10 more days, and the doctor also opined that injury was only likely to cause death, likely to have fatal consequences. Therefore, taking into consideration this evidence, the judges beautifully analyzed the fact situation and came to the conclusion that this cannot be murder. It's only culpable homicide not amounting to murder and punishable under the latter half of Section 304 IPC. Accordingly, he was sentenced to undergo rigorous imprisonment for 5 years. Now we come to the legal issues decided in William Slaney's case. The three judges gave separate verdicts. What are their reasoning? The reasoning given by Justice Vivian Bose, we will first discuss. Since I have got some vocal voice impairment, may I request Urvashi to read that?
Yes, sir, indeed.
Justice Vivian Bose. That
Yes,
judgment is from paragraphs 1 to 73.
Yes. So I'm reading that, like sir
Okay.
said, paras 1
Yes.
to 73 of the William Slaney's case,
Yes.
Justice Vivian Bose.
Yes.
First point, the Code of Criminal Procedure is a code of procedure and like all procedural laws is designed to further the ends of justice and not to frustrate them by the introduction of endless technicalities. The object of the code is to ensure that an accused person gets a full and fair trial along certain well established and well understood lines that accord with our notions of natural justice. If he allegedly commits an offense, if he is tried by a competent court, if he is told that he clearly understands the nature of the offense for which he is being tried, if the case against him is fully and fairly explained to him, if he is afforded a full and fair opportunity of defending himself, if there has been substantial compliance with the outward forms of the law, then mere mistakes in procedure, mere inconsequential errors and omissions in the trial are not regarded as venal by the code and the trial is not vitiated unless the accused can show substantial prejudice.
Beautifully stated. See, the principle has been beautifully stated. If he had a fair opportunity of meeting the case and he had an opportunity to defend himself, then some violations here or there will not prejudice the trial unless he is able to show substantial prejudice. Yes, please read on.
Second point, where there is an express provision in the code, full effect must be given to the plain meaning of the words used. Point number C, where there is no express provision in the code or where there is ambiguity, the question for consideration would be whether the trial was conducted in substantial compliance with the code. If the trial is conducted substantially in the manner prescribed by the code and some irregularity occurs in the course of conducting such trial, the irregularity can be cured under section 537 of the 1898 code.
Yes, that is corresponding to section 465 of the 1973 code, which is presently section 511 of BNSS, as was held in, yes, Pulukuri Kottaya
versus Emperor, that is AIR 1947, PC 67. But if the trial was held in a manner substantially different from that prescribed by the code, as in N.A. Subramanya Iyer versus King Emperor 28, Indian Appeals 257, the trial is bad and the question of curing any irregularity does not arise.
Yes.
Next point, the question of curing an irregularity can arise only when one or more of the express provisions of the code has been violated. The question in such cases is whether the departure is so violent as to strike at the root of the trial and make it no trial at all, or is of a less vital character. It is impossible to lay down any hard and fast rule, but taken by and large, the question usually narrows down to one of the prejudice. In any case, the courts must be guided by plain provisions of the code without straining at its language wherever there is an express provision. Next point, some violations of the code may be so vital as to cut at the root of the jurisdiction or so abhorrent to what one might term natural justice, in which case there may be ex facie prejudice. For example, a refusal to give the accused a hearing, a refusal to allow him to defend himself, a refusal to explain to him the nature of the charge, and so forth.
See, these are all very vital defenses available to vital rights available to an accused facing a trial for murder. If these defenses are denied to him, it is a clear violation of natural justice. Body alterum partem, as you all know. No person can be condemned unheard, whatever may be the charge against him. So if these three vital defenses have been denied to him, that will vitiate the trial. Yes, please read on.
The real question is not whether a matter is expressed positively or is stated in negative terms, but whether disregard of a particular provision amounts to substantial denial of a trial as contemplated by the code and understood by the comprehensive expression natural justice.
Yes.
The effect of charging two persons with murder committed in furtherance of a common intention falling under section 34 of IPC is that each of the accused is unmistakably told that he participated in the crime. Exactly how did he participate is not a matter for the charge to be set out in the circumstances in which the murder was committed. It also means that the accused is informed about the murder and it is immaterial as to who struck the fatal blow.
See, here lies the distinction between section 34 and section 149 IPC. Under section 34 IPC, prior consent and element of participation in action should be there. Each of the accused persons should be sharing the same intention and should be a participant in the occurrence in some way or the other. But under section 149 IPC, the leading feature is membership of the assembly at the time of committing the offense. Participation in the criminal act may or may not be there. Common object under section 149 IPC does not require prior concert and common meeting of minds before the attack. An unlawful object can develop after the people get there. Even though the object of all the members of the assembly may be common in their aim, and their aim may be to commit any of the offences enumerated in section 141 of the Indian Penal Code, the intention of each and every member of the assembly need not necessarily be common. The element of participate in action is also not necessary under section 149 IPC, whereas participation in action is the crux of section 34 IPC. So William Slaney was told that he, along with his brother Ronnie Slaney, participated in the action of causing death of Donald Smith. Therefore, he was also told that he also participated in the action. Therefore, it is not as if he did not participate, but his brother Ronnie Slaney alone participated. Both of them participated in the action. Even though his brother has been acquitted, his role of participation in action remains. That is the distinction between section 34 and 149. Whereas in 149, participation of action is not a must. It is enough that he was present. He was present and he shared the same common object. There is no prior meeting of minds, etc. under 149. Here there was a meeting of minds, though at the crux of the moment, and then he was told that he participated in the action by calling into aid section 34 of the Indian Penal Code. That there lies the crux of the problem. Please read on. H.
A man may be convicted of an offence, although there has been no charge in respect of it, if the evidence before the court is such as to establish a charge that might have been made. Even though they were not charged with any formality, they were tried on evidence, which brings the case under section 237 of the 1898 Code, which is section 221, subsection 2 of the 1973 Code, and is presently section 244(1) of the Bharatiya Nagrik Suraksha Sanhita.
Yes.
Now coming to the observations of Justice Chandrasekhar Iyer, paras 74 to 91.
Concurring only, concurring. Okay. All the three judges concurred.
Yes. In Nanak Chand's case, omission to frame a specific charge under section 302 of IPC in a case where the charge originally framed was under section 302 read with section 149 IPC and section 149 IPC became inapplicable was held to be illegal, whereas in Suraj Pal's case, such an omission was held to be only irregular and curable if no prejudice was caused to the accused. Such a conflict does not arise in a case where two accused persons are charged for murder under section 302 read with section 34 IPC, and if one of them is acquitted, the other can be convicted of murder even without any independent charge under section 302 IPC if there is no prejudice by way of failure of justice.
Yes.
While Section 34 IPC does not by itself create any offence, Section 149 IPC does create an offence as held in Karnail Singh versus State of Punjab, AIR 1954, Supreme Court 204. In a charge under Section 34, there is active participation in the commission of the criminal act. But under Section 149, the liability arises by reason of the membership of the unlawful assembly with a common object, and there may not be any active participation at all in the perpetration or commission of the crime. The overlapping arises in those cases where two or more persons commit a murder in furtherance of the common intention, but it is not possible to say which of them was responsible for the fatal injury or whether any one injury by itself was responsible for the death. There may also be a case where it is known that out of the assailants, one particular assailant was responsible for the fatal injury and the others are sought to be made liable for the result owing to the common intention involved. In this case, the appellant has been individually charged with murder and there is proof that his hand caused the injury.
His hand caused the injury. There was proof that his hand caused the injury. He snatched the hockey stick from his brother's hand and it was he who hit the deceased on the head. So it was his hand which caused the injury. That much is there, proved and charged also. Yes.
The fact that his brother was also sought to be made liable owing to the existence of a common intention is neither here nor there so far as the legality of the conviction is concerned, as there has been no prejudice by way of failure of justice. Lack of competency of jurisdiction, absence of a complaint by the proper person or authority specified, want of sanction prescribed as a condition precedent for a prosecution, etc., are defects that strike at the very root of the jurisdiction. Proceedings taken in such cases in disregard or disobedience will be illegal. Point number D, where there is complete absence of charge, covered by Section 535 of the 1898 Code, 464 of 1973 Code, and presently Section 510 of BNSS. It is for the court to determine whether there is any failure of justice. Where there is any error or omission in the charge covered by Section 537 of the 1898 Code, which is Section 465 of 1973 Code and 511 of the BNSS, the court is bound to have regard to the fact whether the objection could or should have been raised at an earlier stage of the proceedings. In the generality of cases, omission to frame a charge is not per se fatal.
Yes.
In the case of a sessions trial, the code requires that there should be a charge and it should be in writing. A deliberate breach of this basic requirement cannot be cured by the assertion that everything was orally explained to the accused and to the accessors of jurors, and there was no possible or probable prejudice. Where the conviction is for a totally different offense from one charged and not covered by Section 236 and 237 of the 1898 Code, that is Section 221 subsection 1 and 221 subsection 2 of the 1973 Code, and Sections 241 and subsection 2 of the BNSS. If the charge is for a minor offense, then there cannot be a conviction for the major offense like grievous hurt or writing or murder. The omission to frame a separate and specific charge in such cases will be an incurable irregularity amounting to an illegality. Point number F, where the charge is a rolled up one involving direct liability or constructive liability without specifying who is directly liable and who is sought to be made constructively liable, the absence of a charge under one or other of the various heads of criminal liability for the offense cannot be said to be fatal by itself, and before a conviction for the substantive offense without a charge can be set aside, prejudice will have to be made out.
See, beautiful observations by the judges. Now we come to the last of the three judges, Justice Said Jafar Imam.
Right. The appellant William Slaney was charged with murder and nothing short of it, although it was stated in the charge that the offense was committed by him in furtherance of a common intention. If the evidence failed to prove that the offense committed by him was in furtherance of the common intention, it would nonetheless be his offense, namely murder, if his act in law amounted to murder. The law does not require in such a case that a separate charge for murder should be framed because the charge of murder was already on record. Strictly speaking, there is no substantial conflict between Nanak Chand's case and Suraj Pal's case, and the question raised by the reference does not arise in this case. As per the provisions of the CRPC, a charge must be framed for trial of warrant cases and cases before a court of session and the High Court. While Section 233 of the 1898 Code, that is Section 218 of the 1973 Code, which is presently Section 241 of BNSS, insists upon a separate charge for every distinct offence, it permits a single trial on several charges in the cases mentioned in Sections 234, 235, 236, and 239 of the 1898 Code. And the 1973 Code would be sections 219, 220, 221 subsection 1 and 223. And presently sections 242, 243, 244 1 and 246 of BNSS. Section 233 of the 1898 Code, that is section 218 of the 1973 Code and presently 241 of the BNSS, is a mandatory provision, and the force of its direction is not weakened by the fact that another provision of the code permits a conviction of the accused for an offence with which he had not been charged. In such a case, that is, where the code permits a single trial on several charges, no question of illegality or irregularity arises, as the conviction is expressly authorized by the code. The framing of a charge in trial of cases in which a charge is required to be framed is one of the important elements in the mode of a trial. On the charge framed, after it has been explained to the accused, the plea of guilty or not guilty is recorded. If the accused pleads guilty, certain consequences follow. If he pleads not guilty, the trial must proceed according to law. When a charge is not framed, obviously no plea of accused with reference to it is taken and the trial has proceeded without such a plea. Framing of a charge and the recording of the plea of the accused is a fundamental provision of the code concerning the procedure in a criminal trial and not merely a ritual.
There's a beautiful observation. So the framing of a charge and the recording of the plea of the accused is a fundamental provision of the code concerning the procedure in a criminal trial and not merely a ritual. So without framing the charge and without the accused being told what the case he has to face, he has to meet with, it will result in travesty of justice. He should be told that you have to defend this particular case. This is the offense with which you are being charged, and you have to face the trial on this charge. Otherwise, how can he plead guilty without pleading guilty or not guilty? How can he plead guilty or not guilty? If he pleads guilty without knowing what the charge is, he might be convicted without even a trial. And if he pleads not guilty also, that opportunity should be given to him, for which framing of a written charge and reading it out to the accused in the language known to him is an essential prerequisite. Yes, please read on.
Total absence of a charge from start to finish in a case where the law requires a charge to be framed is a contravention of the provisions of the code as to the mode of trial. Conviction of the accused of an offence in such a case is invalid and the question of prejudice does not arise. It will be illegal to convict the accused for the offence under 302 IPC without a charge for the same in a case where the charge is for section 302 read with section 149 IPC. The omission to frame a charge under section 302 IPC must be regarded as a deliberate act of the court by way of notice to the accused that he was not being tried for section 302 simpliciter. Hence, the conviction of the accused for the offence under section 302 IPC alone will be invalid.
See, supposing in a case where the charge is framed against A1 to A6, there are 6 accused for murder punishable under section 302 read with section 149 IPC. And the charge also says that it was A1 who inflicted the fatal injury on the deceased. Then on the court either holding that A2 to A6 were not members of the unlawful assembly, or that the common object shared by A2 to A6 was only to give a beating to the victim, but never to commit murder, will it be open to A1 will it be open for A1 to contend that he cannot be convicted for murder without an independent charge under section 302 IPC? So I'm speaking of a case where 149 becomes inapplicable, because but the charge specifically said that you first accused, it was your hand which caused the fatal act of murder. In such a case, he cannot turn around and say, no, there is no independent charge for murder against me. So therefore, while that is why I said at the outset, framing of a charge is a very responsible act of the court, and if the court is very careful in doing that, the accused may not go scot-free. So in a case where there is evidence to show that it was a particular accused who actually inflicted the fatal blow, that also can be the subject matter of a charge, so that ultimately if 149 becomes inapplicable, he may not go scot-free by raising a contention that, no, I have not been separately charged under section 302. So that's a very the courts have to be very careful while framing the charge. Yes. Yes. Finally, Justice Imam also agreed that the conviction of William Slaney be altered from section 302 to section 304 IPC, and the sentence to be imposed on him shall be rigorous imprisonment for 5 years. So this is a case where the judges noted that that Nanak Chand's case and Suraj Pal's case, there is no conflict between them. Even if there is a conflict, that was not applicable to a case where accused was charged with murder, right, with the aid of section 34 IPC, where participation of the accused is implicit in the charge, whereas under section 149, participation is not implicit in the charge. It's only presence of the accused and the sharing of common object. These are the distinguishing features of section 34 and 149. And section 149 IPC is an independent offense, and there can be a conviction under section 149 IPC, whereas under section 34 there is no conviction. It is not an independent offense. These are the differences to be noted. From the next session onwards, we will go into the provisions in the code proper for while framing charge and while discharging the accused. What are the criteria to be applied? What is the legal framework, and what are the citations governing the process of discharging and framing a charge against the accused? Yes, with that we conclude today's session. Thank you. Any questions?
If there are any questions, I request our viewers to please put it in the chat box. Well, thank you so much, sir. Thank you for this enlightening session. I'm sure your deep insights into this concept and the wonderful way which you explained the entire case, I'm sure everybody must have benefited from that. Thank you so much. It is an absolute privilege.
You read it extremely well. You read it extremely well, Urvashi. Beautifully well.
Thank you. Thank you so much, sir.
Thank you.
And also a big thank you to all the participants for joining today. Before we break, there is something very important I want to, tell you all about. It's a value-packed opportunity for all the judiciary exam aspirants out there. I'm talking about the Judicial Service Examinations Preparation course. Please hear me out for some time as I tell you about this in brief. This is a new course that has been launched by the LiveLaw Academy. It's an approximately 18-month comprehensive online course and is designed to help you in your judiciary exams. The classes will be conducted by expert faculty, including retired Justice V. Ramkumar, as you've already seen sir's expertise, and Justice K.A. Matthew. Apart from this, 4 experienced faculties are there, also a dedicated faculty for the Hindi language. You also get free LiveLaw subscription, case compilations, and much more, and all of this at a very affordable fee. But most importantly, let me tell you, for a limited time period, the LiveLaw Academy is offering a 25% discount on the course fee. So I urge you all that this is a must-check opportunity. In case you want any more details, you can visit www.livelawacademy.com and you'll find all the details there. You can reach out to us on mail, call, etc. Once again, thank you so much, sir. It was a privilege to host you. And thank you everyone for joining. Hope you all have a great evening.